Mr. Levitt, anything from you before we get started?
No, Your Honor.
Okay. All right. Go ahead, sir.
Thank you. I'll go through the issues as I see them. I'm sure if I miss any issues, uh, Counsel McLean will bring those up. The first that I will address is the start date of the new order. The state filed their motion to adjust on July 11th, serving the parties shortly thereafter by mail. In August, both parties hired counsel and notices of appearances were filed. And towards the end of August, discovery requests were sent out. Because of those pending discovery requests, the parties agreed that the state could withdraw from the motion because both parties were represented, and it would allow time to exchange discovery. Um, so, from mother's perspective or petitioner's perspective, we are asking that support begin, or the new support begin August of 2025. Um, and the reasoning is what I just explained, because the state's motion was filed in July, parties were on notice in July. Before that petitioner had reached out to the state or to DCS to begin collection and to begin enforcement. The next issue that I will address is just kind of the traditional issues of where you set the parties' incomes. As to petitioner's income, she is a W-2 employee of her husband's business, Pacific Pole Inspection LLC. Um, Her income is relatively straightforward. It's the same month to month, and I don't believe there are any disagreements as to how her income was calculated pursuant to her W-2 employee income.
Mhm.
The disagreements and the trickier issues come into play with respondents' request to include Pacific Pole Inspection as a uh, source of income for petitioner herself. And I haven't received any notice that the claim of that being a community asset was rescinded, so I'm going to go ahead and go into it. But the parties were married in 2028 or 2018, is that right? Let's see. Yeah, 2018. Mr. Pionio filed the certificate of formation for that business in May of 2013, 5 years before marriage. Petitioner's position is that the business is her husband's separate property, and pursuant to the child support statute, income from a spouse, including business income from a new spouse, is to be disclosed to the court, which it has been, but is not to be included for purposes of child support. Because of that, the business income itself for the business Pionio, or I'm sorry, Pacific Pole Inspection LLC, should not be included for petitioner's income. I understand there may be some argument as to the parties receiving a benefit, a personal benefit to the business or to the marital community from the business. Respectfully, that is outside of the scope of this court's purview for purposes of child support. It would still be the source of the income is still from that business itself. And so it would still be considered the separate income of petitioner's current spouse. As to the rental properties, I'm aware of some disagreement as to how the net income was calculated. So we went through and provided new calculations at the end of last month. Those were attempted to be filed under seal. The clerks rejected that, so on the 27th, they were filed as just a submission document. Instead of a gross or a 10% estimate for all transition costs and repair costs, we went through and delineated exactly what petitioner and her spouse paid throughout the years for which they filed taxes, 2022, 23, and 24, showing what those costs actually were and providing an average of those, then adding that back in. There were no other disagreements of which I'm aware as to how to calculate the income from the rental properties. There was a disagreement about whether to include one of the properties. I believe it was the Juanita property, Juanita. That property was sold and it was excluded from the income calculations, both before and after receiving respondents' materials. So we're asking that Your Honor set the petitioner's income as her W-2 employment income gross of $5,000, taxes, FICA deductions per her pay stubs, the other mandatory state deductions also per her pay stubs, results in a net income of $3,500. And then on top of that would be her 50% share of the gross rental monthly income and the normal business expenses, which brings her income up somewhat. All of that was filed as a sealed or non-sealed submission on the 27th. As to respondents' income, I didn't see necessarily an analysis or how the numbers were arrived at from his pay stub from respondents' materials. We went through and provided the income analysis showing the average per pay period, gross income, and the average monthly. So we took the year-to-date income, divided it by the number of that pay period was in the year. I believe the most recent pay statement provided was his sixth. I'm sorry, that is his wife's income. So it was the 22nd out of 24 pay periods in the year. Year-to-date totals divided by 22 gives you the average per pay period amount. Multiplied by 24 is the yearly amount. Divided by 12 is the monthly amount. And that is on page 6 of our financial source document submission filed on the 27th. Respondent should also receive a credit for how much he's actually paying for the children's health, vision, and dental insurance. We provided our calculation for those expenses, which was also provided from counsel herself. Those are attached to the reply declaration filed on February 23rd. As to the other issues of which I'm aware, we have respondents' defenses. Well, I'll get to the equitable defenses next. But first, I want to address the request for attorney fees based on intransigence. It seems like most of these intransigence claims were coming from assumptions about things that Mr. Rice believed Ms. Peonia was doing and not necessarily things that she actually did. One of those was his claim that she lied to support enforcement or didn't disclose those direct payments. Attached to her reply declaration as Exhibit E are all of the emails she exchanged with support enforcement page 12 of that document, which I believe is the second page of Exhibit E, includes the email where Ms. Pionio says the past due amount is incorrect. Jesse has paid me the $600 a month until August 2022. And I believe there may have been some evidence provided that he actually paid through September. So the difference would only be 1 month. But anyways, he assumed that because of the way DCS was calculating his arrearage, it was significantly more than what he anticipated. He assumed that Ms. Pionio was not providing that information to DCS. She did, in fact, and DCS came up with a different calculation. His other basis for requesting attorney fees is that she filed a motion for adjustment versus a petition to modify child support, and the relief that she was requesting exceeded the scope of what is typically allowed in a motion to adjust child support. The case law that I provided, I believe the case was directly on point, stated that there really is no detriment to the non-moving party facing a motion to adjust rather than a petition for modification. In this case, I will also note that respondents' discovery requests were provided and responses to those discovery requests were provided well before he filed his petition to modify. So he did face really no detriment based on that procedural choice. So essentially, that is a harmless error. He should not be entitled to attorney fees because she chose to file a motion to modify rather than a motion to adjust rather than a petition to modify. Finally, that was also the motion that the state brought before either party had retained counsel. Therefore, she filed the same motion. Then we get to the request for relief from child support arrears. There are actually three bases that Washington courts have found to support relief from child support arrears, and those are your three equitable defenses. Laches is one, equitable estoppel is another, and I'll have to look at my old brief for it, but there are three bases. Laches and equitable estoppel can essentially be analyzed together. One of them has three elements that focus on the delay, that's laches. The other focuses on an act or inact that caused harm. Respondent's position seems to be that twofold. Essentially, we had an agreement, and I relied on that agreement in allowing her to claim the tax deductions. The evidence that he provides cannot meet that clear and convincing standard because the text message that he provides shows that there was not an agreement at the time that child support began or ceased being paid. He stated in that text message himself that no, he still wanted to claim the children. It was not in reliance on some agreement not to pay child support. It was not in reliance on that he allowed her to claim the children. That was done well after the fact. So there essentially is no harm, and then no harm for the equitable estoppel claim. As to the laches claim, there has to be damage resulting to the defendant from the delay. In this case, the delay was the delay in reinitiating state enforcement or reinitiating state collection. And the applicable quote here is that respondent cannot prove damages simply by showing he has to do now what he was legally obligated to do for years. As to the tax issue, that can be remedied with the new order quite easily, allowing respondent to claim the children once he becomes current on his child support obligation, or allowing him to claim for 1 to 2 years before going back to alternating. And let's see, with that, I believe I have addressed all of the known disputed issues. Yeah, a respondent has to prove clear, cogent, and convincing evidence standard. And so it's less than reasonable doubt, but more than preponderance of the evidence. We provided evidence that there was some sort of agreement to stop collecting child support. Petitioner provided in her reply declaration her explanation. There was quite a bit of hostility towards her that was affecting the children. She couldn't think of any other way to get that hostility to decrease other than by canceling child support. Petitioner or respondent's position appears to be that they agreed in 2022 to cancel child support and nobody would receive the benefit of that, not in 2022, not in 2023, but at the earliest in 2024, at the time that the parties would file taxes for 2023. It just doesn't add up. So for that reason, we're asking that his equitable defenses against child support arrearages be denied. Is there anything that Your Honor feels you need more explanation or argument as to petitioner's position?
I don't think so. I think what I'll do, I'll hear from the other side and then give some rebuttal. And I do have just general questions that might be more of a group discussion, just kind of making sense of how this all played out over the years. But rather than kind of pin that on petitioner necessarily, I'll hear from respondent. Sure. And we can have a brief discussion. Thank you, Mr. Levitt.
Thank you.
All right, go ahead, Ms. McLean.
Thank you very much, Your Honor. So on behalf of Jesse Rice, the respondent in this matter, as you know, I'm usually a little more verbose. So, and to sort of dovetail into your initial suggestion there about having a question about the history, that's exactly where I'm starting at. These parties divorced back in 2017, at which time the children resided primarily with Ms. Pionio. At that time, Mr. Rice was ordered to pay $1,138.59 a month that started in July of 2017, and payments were made directly to Ms. Pionio at that time. There was written correspondence dated May 1 of 2019 from Ms. Pionio acknowledging to the Office of Support Enforcement that he was current in his support. And this is, and I guess that maybe I should ask, are you working off of my trial notebook that we sent over, or so would you want me to refer to tabs, or do you want me to refer to clerk's papers?
Tabs would be great because I have both of your binders in front of me.
Okay, so if you take a look at our tab H, exhibit C, C as in cat, you'll see that she's written this letter dated May 1 of 2019 that says that he's current and up to date on all child support payments through April 30th of 2019. So as of that date, he's current. The parties then agreed to modify the child support order, and they entered into a joint custody parenting plan in July of 2019. The child support order that was entered on July 23rd provided for Mr. Rice paying $800 per month in child support. That commenced July of 2019. And the child support was deviated due to the joint custody. At that point, my client was not, I don't believe he was remarried, and but he didn't have at least the whole family deviation for his other two children. So the deviation at that time was based solely on the joint custody. And that took effect July of 2019. There was another child support order that was entered November 17 of 2020, and that's the existing current child support order. That child support found that my client's net income at that time was $6,471.86, and Ms. Pionio's net income was $2,893.73. And it said child support at $600 per month, effective December 1 of 2020, again with payments going directly to Ms. Pionio. So one of the issues or claims that has been floating around here is that she did not provide proof of those payments or allow claim to those payments when she asked for enforcement. And so part of these arrears are for that $600 per month that my client was paying direct. If you take a look at our sealed financial source document, and I've provided this to you at at tab L, those are all of his bank statements from, May 1 of 2019 through May 30th of May 31, of 2022. And the reason we provided those was to show and verify his payments. We provided the case payment history that Ms. Pionio had produced to us. That's at pages 4 and 5 of that same exhibit. And then we produced, so you'll note that they do not, this calculation or sheet does not reflect his direct payments to her between November 20, so after November 24 of 2020, through his payments in May of, not May of 22. Oh yeah, I think it would have been May of 22 because that's when they reached the agreement. So we had to produce all of his bank statements to provide proof of that because that hadn't been given, even though the order provided for a direct payment to her at that time. Also in that November of 2020 order, Kate, the child Kate, was allocated to my client as a tax exemption, and to Ms. Pionio, she received, is it Courtney? Oh, Hallie, pardon me. Hallie as a tax exemption. It also ordered my client to pay health insurance for the children. And I would note that the child support order at, I believe it's paragraph 22, allocated uninsured healthcare expenses and reasonable daycare expenses. Those were the only additional expenses that were allocated. And my recollection, although I'd have to turn my back and pull the, actually, no, I have it. If you take a look at Exhibit G, that's the existing final order of child support. And if you take a look at paragraph 19 on the taxes, it talks, and I guess I just picked up on this when during Mr. Levitt's argument, he claimed that, well, he should only be allowed to claim the children if he's current in his child support obligations. Paragraph 17, apologies. Paragraph 17 does not require a parent to be current in their child support in order to claim the child for purposes of taxes. So that's a new claim and allegation. That existing order did not require that. Again, however, in 2020, there is no claim for back child support by Ms. Pionio. And again, she asked OSC to stop collecting the child support and provided for direct payment to her. The payments that we have provided in our tab L are also allocated in my client's declaration that's filed at tab H. The calculation at Exhibit A. This is the calculation of the child support at $600 per month through September 1 of 2022. He made consistently made payments and actually made his last payment on September 9 of 2022, again, because of their agreement. And then you see from the documentation that based on Ms. Pionio's request, she now has the Office of Support Enforcement garnishing his wages, and those garnishments started July 16 of 2025, and they continue to this day. In September 19 of 2022, the parties did agree through texts that there would be no child support, and Ms. Pionio would claim both of the children as tax exemptions. And again, that's at our tab H, and it's Exhibit D. And it's notable that it is Ms. Pionio who reaches out to my client. She's the left-hand justified on September 19 of 2022. She says, hey, I'm going to try and get all the info to my attorney today since I'm dropping all support. That's her pronouncement. She's dropping all support. I'm going to change it so I can claim both girls on taxes. Are you okay with that? He basically says, look, I've paid child support for 9 months. This is what I've been planning for this year. I want to be able to claim the one child this year that I've been doing, and then it would start the following year. And look at what their tax returns show. The tax returns show exactly that. My client claimed the one child in 2022. She claimed both children in 2023. She claimed both children in 2024. So that's her offer, his acceptance, and both of them have relied and acted upon that.
Let me, just so I don't lose this point.
Sure.
So when I look at this text message, I struggled with this being offer and acceptance. And so there must be something more that happened. And that was kind of what I was getting at with some of the historically. Something happened here. Did they call each other and he finally gave in and agreed to it, or what? Because the text message would show she threw it out there. He said, nah, not interested. So then what?
They had further conversations after the fact, is my understanding.
Just oral conversations. I mean, or not just, but they had oral conversations. Then no follow-up text that I'm missing.
Not that I'm aware of.
Okay.
As far as follow-up text, and even if the court record would reflect that Ms. Pionio was also shaking her head as it related to communications after the fact by phone. So my client had paid child support through that $300 payment in September of 2022. They both filed their taxes. If you take a look at her 2022 tax return that's filed under their, I think it's Exhibit 16, 2022 tax return is on page 241. Sorry, I didn't mean to cover you up. Is on page 241. You'll see that she claims Hallie. And then if you take a look at the 2023 tax return on page 177, and I'm referring to the Bates numbers that are identified below. I'm sorry, it's 176, apologies. She claims both Hallie and Kate. And then the 2024 tax return at page 92, again, she claims both Hallie and Kate. So she's relied upon that. She's received a financial benefit for being able to claim those girls, and that is the source of their agreement. So they've both followed through with that. I would also note, first off, and I'm getting a little astray from my history here, but just because it's fresh and the court had asked about it, the courthouse doors have not been closed to Ms. Pionio. The Office of Support Enforcement has not been closed to Ms. Pionio. She very well could have in 2022, when he stopped making direct payments to her, asked them to do direct collection against him, garnishment against him. She also could have filed a contempt motion. She's done neither of that. And because of that, my client has relied upon their agreement in not making payment. The other thing that I would point out is I'm still a little baffled as to why we are arguing this, because when I go to Ms. Pionio's own declaration that was filed on February 23rd of 2026, and I'm not sure which clerk paper this is. I didn't mark that. I apologize. And I didn't have it identified as a number in their notebook or in any event.
Yep.
Her declaration filed February 23rd of 2026, page 2, line 24. I am not seeking a judgment against the respondent for child support arrears. So I'm not, are we arguing this or not arguing this? If you go back and look at the documentation that she files from her communications with the Office of Support Enforcement, she says, this is on exhibit, so this is exhibit E. The very first one says, the support owed now is $600 per month starting December 1 of 2020. So again, they still don't know about all of his payments that he's made and the tax or the bank statements that we've produced. She said, the caseworker, Ms. Rakestraw, I believe is how you pronounce Anna Rakestraw, says, you'd mentioned you wanted to forgive all or some of this debt. So back in May of 2025, Ms. Pionio is telling her caseworker she's wanting to forgive all or part, and her own declaration says, I'm not seeking a judgment. So I guess the question is, doesn't that mean that she's acquiesced in the argument that she acknowledged that she forgave that $600 in return for being able to claim the children and that they've moved forward from there? She goes on to say, and this is where counsel is suggesting that she advised OSC that he in fact paid her. This May 14th email, Ms. Pionio says, the past due amount is incorrect. Jesse paid me the $600 a month until August of 2022. So the difference should be from September 22 until current, not from December 2020. I'm not sure if I'm going to forgive that debt or not yet. This is in May of 2025. Again, acknowledging by implication that they've already agreed that there's not to be a child support order and that they both acted on that. Going back to the history in this, the parties agreed to modify the parenting plan in 2023. Again, there was no discussion about child support, no discussion about arrears. The parties continued with the no child support payments, and Ms. Pionio, in her declaration for the first time, as I indicated on page 2 of that February 23rd, says she's not seeking this judgment. But then she does say that she wants the court to deny the relief requested in the child support order. I'm assuming that's the other relief requested by my client. In regard to the next action that took place after the parenting plan was modified in 2023, and again, I would note the parenting plan provides absolutely no 191 factors, no suggestion that my client's harassing her, pestering her, or that he's been inappropriate in any way. There's no text messages that support that conclusion. This is simply an attempt to garner pity from the court to suggest that she was somehow under some undue influence after the fact. And my client adamantly denies that. The state filed a motion to adjust child support, including providing a memorandum on a stepped up basis. At that point, no discovery had been conducted, and there was no whole family deviation that had been considered, given that Mr. Rice has 2 dependent children within his household. The state's motion was withdrawn. By agreement, it was withdrawn. And if you look in the record, you'll see that there's a notice of withdrawal and a motion and request to strike the hearing. Therefore, I would submit that the state has effectively withdrawn their action and that jurisdiction lapses at that juncture as it relates to that July filing. There was no objection filed by either party, and therefore I would ask that you conclude that the jurisdiction is lost as of that date, and there would be no retroactive application back to that date. Ms. Pionio then files to adjust on November 25 of 25. And as part of her adjustment, she asked to include proportionate share of extracurricular activities, education expenses, including necessary expenses for public school. I'm not sure exactly what those are outside of what's already been considered by the committee in establishing basic child support calculations. She wants establishments for driver's education costs, college applications, and automobile insurance costs. You have not one shred of evidence submitted before you from Ms. Pionio outlining potentially what those expenses are. There is not one decision-making process in the parenting plan related to extracurricular activities, driver's license expenses, and driver's licenses, which obviously are not a right. They're a decision that parents are to make. And I would submit that once you take a look at the totality of the financial circumstances between these two parties, certainly that could be abused by Ms. Pionio running these kids all over the place and then asking my client to pay. I would also note, as it relates to extracurricular activities, you do have evidence that these parties have been able to communicate on extracurricular activities, and the bank statements show where Mr. Rice has in fact made voluntary contributions towards the girls' volleyball and other expenses for them. The court should leave them in that position because there is no parenting plan modification here before you, and my client should not be cut out in a child support action on absolute rights to be able to make decisions relative to financial impacts for him. So we would ask that you deny any requests for those additional expenses to be added into the parenting or into the child support order. But I would also note that that's beyond the scope of an adjustment. An adjustment is simply what are the incomes, what are the child support amounts, and so I would submit that it is improper to be here in front of the court on an adjustment. If you compare Ms. Pionio's adjustment motion compared to the state's, you'll note that the state didn't provide for all of those additional expenses and whatnot, because again, that's not proper. That isn't something that had already been ordered by the court. We filed a petition to modify the child support specifically for the reason of addressing these back child support arrears that were now being claimed contrary to the agreement of the parties. My client has been put in that position of having to file a petition, incur expenses related to that, because Ms. Pionio now decides that she doesn't want to honor the agreement that they had come to and had been acting on. Our modification asked the court to adjust those arrears based upon the agreement, establish an overpayment for the collection that's been in place by the department since July of 2025. And we're also requesting a contribution towards fees and sanctions as the court deems appropriate. So if you take a look at their Exhibit 2, that is the state's motion for adjustment. And again, as I indicated, there was no additional or other relief requested. And depending upon the amount ordered, if there is a 30% increase, then that would allow for a step increase. And that's the memorandum that's provided by the state at their Exhibit 3. The state's proposed child support order did not recognize my client's other two children. One is a biological child, the other is an adopted child. We have provided under our Exhibit M those sealed health records as it relates to the birth certificates for both of those children, and that those are my client's dependent children within his household. So as you analyze this, we have my client and his wife who are supporting 4 children, 2 children within their household, 2 children primarily with Ms. Pionio. Ms. Pionio and her husband are supporting 2 dependent children within their household. So again, because of the failure to address the the deviation for my client's other children, my client also needed to file the modification in order for this to be properly before the court. Let's talk about incomes. So obviously my client is a W-2 wage earner. You can see that there have been substantial swings between my client's income. Off the top of my head, I believe that there was 86,000 in income in 2024 and 156,000 in 2025. You'll also note that there are referral bonuses that are not guaranteed. There's additional income points that are, again, not guaranteed. I had calculated his gross at $13,333 with a net of $9,828. Mr. Levitt has calculated his net at $10,567. So the difference between our nets is about $700. If you look at his wage stub, and I'm specifically referring to exhibits or tab C, page 1, you'll note that his net pay was $4,287.
And I'm sorry to interrupt you. I do not have your trial exhibit tab. So if you could just say
I'm sorry.
Document that is
the sealed financial source document.
From February
11, yeah.
Thank you.
You're welcome. So page 1, if you take a look at the bottom line there, his net is $4,287. Add back in the $550 child support, puts him at what, $4,800 and some odd dollars. He's paid twice a month. So if you take a look at the reality, he's got $9,675 a month based on this, which is consistent with my child support calculations. My client does pay, and Mr. Levitt provided my email outlining the calculation of the insurance costs for my client's health insurance. My client and his wife double cover these kids at their expense. We also provided my client's wife's breakdown. And when you add that in, the cost for my client and his wife to cover these children doubly on their insurance is $282.11 a month. And if you take a look at Exhibit L, you will see the proof of the insurance costs. And I'm sorry, that's the sealed financial source documents from December 8. The proof of the costs to cover the children on both sets of insurances. The first page, page 1, is my client's costs. Page 2 and 3 is my client's wife's costs. And we did produce all of that information clearly to the court and outlined those calculations. Take a look at the financial declaration from my client, and this is at tab K. Again, his financial declaration from December 9. His monthly expenses, installment expenses, include a mortgage of over $4,600 a month. Again, he's got the 2 additional children that he supports. His overall health insurance costs are $639.31 to cover himself, his wife, and the children. He's got $760 in vehicle payments, $850 in credit card payments, auto insurance of $350 a month, utilities of $603, and we haven't even gotten into food, fuel, clothing, discretionary expenses, and whatnot. Just the installments total $7,833. His overall financial expenses outlined on page 4 total $10,419. In 2023, he and his wife grossed $163,000 compared to Mr. and Mrs. Pionio at $763,000. In 2024, my client and his wife grossed $210,000 compared to Mr. and Mrs. Pionio at $707,000 a year. So they are they're 3.5 times my client and his wife's income, and yet it's my client and his wife who cover the children on insurance, and provide for 2 other children. And under the Scanlon case, which I did not cite in my case law, but under the Scanlon case, and I can provide you the site for that, the court is to take a look at the overall financial circumstances in making a determination of an appropriate child support amount, particularly when we're talking about deviations for other children, for overnight credits and the like. So you are charged with, and that's clearly outlined even in the statute, you are charged with taking a look at the totality of the financial circumstances within each household in making an appropriate child support, and that the child support schedules are there as guidance based on the parents' alone income. Ms. Pionio's income and expenses. First off, I agree that she's paid $5,000 a month from her working for her husband. I would ask the court to take a look at their tab 5. Tab 5 is the sealed financial source document that was filed by the state. And if you take a look at page 18 of that document, you'll note that oh, wait.
Yeah.
Okay, so this is the employment security data. Take a look at fourth quarter you can see from third quarter 2023 through fourth quarter 2024, Ms. Pionio works 120 hours a quarter or 40 hours a month. So she's working 9.3 hours a week. That means she's making $125 an hour. If the court were to impute her, as technically you should consider, if you were to impute her at her current wage at full time, that puts her gross at $260,000 a year or $21,666 a month. Gross. My client doesn't have that benefit. My client has to work full time. My client has to work those hours in order to earn comparable income. But that's a choice that the Pionios are making. And the court needs to take that into consideration because the statute talks specifically about a parent being imputed at full time if they are voluntarily underemployed. And she certainly is at 9.3 hours a month. 9.3 hours a week or 40 hours a month. Rental income. We did object to the arbitrary 10%. What they were allocating as far as rental expenses are clearly delineated in the IRS forms. They're obligated to claim those if there is that legitimate expense. They did not make those claims, and the attempt to recoup those expenses, again, they were not claimed on the tax return. I used the tax return, which is what they've submitted to the IRS and what the IRS has accepted. I did add back in the depreciation, which is an on-paper deduction. And as you can see, and this is in my client's a declaration that was filed in February. So tab A, exhibit A, I've provided the calculations of her and her income, her husband's income, the business income, and the rental income. And again, I took what they had in their tax returns, I added back depreciation and then divided that by 2. So in 2023, her share of the rentals was $26,943. In 2024, it was $13,984. So again, obviously things change, but those are investment opportunities for them. Rents, as we know, have continued to increase, and obviously they're working down on paying off mortgages and the like. Let's talk briefly about Mr. Pionio's business. So most recently was the LLC formation documentation. Just because an LLC is formed does not mean that that business has been operating. Again, if you take a look at, and this is in our tab H, which was my client's declaration from December 9 of 2025. Exhibit B is from the Department of first off is their marriage certificate. And then the next 2 pages are from the Department of Revenue. And the Department of Revenue is when they're reporting their income. And you'll note that the Department of Revenue first identifies that the Pacific Pole inspection is an active business with them, first issued January 11 of 2019. There is no proof that this business was operating prior to that date identified by the Department of Revenue. So the fact that he created this LLC prior is not does not prove the fact that the business was operating. Department of Revenue identifies 2019. In addition, I mean, the optic in and of itself is that in 2023, they pulled distributions from the business of 260, I'm sorry, that was 2024. In 2023, they pulled $306,027 in distributions. Plus, they had ordinary income of $253,000. I added back in the depreciation of $54,000, and he had his officer compensation of $36,000. So that in and of itself, just the business alone was $613,000, of which again this family is benefiting by having these distributions pulled. In 2024, $268,915. That's more than my client and his wife together earned for the entire year in 2024. They're able to pull that out of their business and have that within the household. So again, when we're talking about additional expenses and whether or not Ms. Pionio has been damaged in this circumstance, I would suggest the optic is that they are very well off, and that she had no reason not to be able to come into court and retain attorneys as it relates to arrears. Moving to, so for purposes of child support, I have set her net within my child support calculations. If you take a look at their tab 16 of her financial declaration, she claims household expenses of $8,023. And clearly their income is well able to meet all of their expenses at least fourfold each month. I would also note when we're talking about veracity, if you take a look at Exhibit 16, their financial declaration, page 70, Ms. Pionio claimed that her husband grossed $4,000 a month. Now, obviously, that doesn't take into consideration the business income, the business distributions, which well exceed that. And she has an obligation and a duty of candor to the court, and clearly she had not disclosed that. That was filed as of December 1 of 2025. And as you can see, again, from their own documentation, we were having difficulties getting discovery out of them. They were not giving up the business tax records, even though it was clearly requested. And that was as of December 5. This is, if you take a look at her declaration that's filed February 23rd of 2026, they've attached as Exhibit B my letter dated December 5 to Mr. Levitt outlining the discovery deficiencies. Very first one, I requested all tax returns for the past 3 years. I've only been provided personal tax returns. Please produce the business tax returns, as there's K1s that are identified within the personal tax return. It isn't until I get the business tax return that I'm able to discern the amount that they're pulling as far as distributions from the business. So again, you can see from the, 2-page correspondence, all of the issues that there were with regard to discovery and their response on December 22. So we have this motion that's been filed, and still we're struggling to get discovery. That's one of the reasons why the state withdrew and canceled their motion, was because Ms. Pionio was not cooperating with discovery, and the correspondence concludes and proves that. As it relates to the legal arguments, we are asking the court to recognize the doctrine of laches and an equitable estoppel against Ms. Pionio's effort to collect the last arguably 4.5, well, I guess 5.5 years if we go back to this 2020 timeframe. The parties negotiated, they reached the agreement, they acted on it. Mr. Rice didn't pay. Mr. Rice didn't claim the girls on the taxes. Ms. Pionio claimed the girls on the taxes. I cited the Capetillo case, and that discussed not enforcing support retrospectively if it doesn't work an injustice to the custodian. And clearly, the financial circumstances here would not work an injustice to the mother. But her waiting and delaying to bring this action has put my client at a disadvantage, because now he's unable to retroactively modify the child support to raise the issues of deviations due to his other 2 children that are now appropriate or ripe for modification or for deviation. Latches should be applied to Ms. Pionio. Again, she was aware she was not receiving child support since August of 2022. As I indicated in the history, she's not filed contempt. She's not claimed any arrears up until she enacted enforcement with OSC in July of 2025. She's delayed this action by over 3 years since their discussion and action, and she's received benefits moving forward. Commencing this action 3 years later, I submit, is unreasonable delay because it doesn't allow him to protect his interests and claims. Mr. Rice relied upon their agreement, and she does not deny that there is an agreement. And again, even in her own declaration filed last week, she acknowledges that she's not asking for delinquent child support. I would argue again that this is simple contract law. You've got an offer, you've got an acceptance, you've got action, and you've got reliance. My client would be damaged by the delay of the child support, as I've outlined in my argument and within his documentation. The damage to him at a bare minimum is the $600 per month, which was $19,642. And yet the Office of Support Enforcement still has $32,000 in arrears that they say that they're collecting, even though, again, we've produced all of the bank statements. And this is, again, outlined even in the communications that Ms. Pionio has with her caseworker. She doesn't understand the differences in those calculations. And it's, again, because the Office of Support Enforcement is kept in the dark, and Ms. Pionio has not acknowledged those payments that she was receiving directly pursuant to the court order. Ms. Pionio cites, or I guess it would be counsel technically, but on behalf of his client, cites the in re marriage of Fox, and claims that it stands for the rule that parents cannot agree to waive child support. And I heard you at the beginning of this. You said you went back and you took a look at the relevant case law. I would argue that Fox is not an appropriate case as it relates to the facts in this case. The Fox case dealt with an antenuptial agreement that waived the right to spousal maintenance and attorney's fees, and the footnote that's cited within that indicated that Mr. Fox acknowledged waiver to child support in such an agreement would also be void. And I would argue, and it goes on to talk about the Pippins case. The Pippins case at page 808 identifies that future child support belongs to the child. Back child support belongs to the parent. And so the parent always has the ability, and even the communications with the Office of Support Enforcement acknowledges that Ms. Pionio has the right to waive back child support. And they direct her to the form to fill out and the amount that she's willing to waive. So a parent always has the right because, as you know, child support accrues as a judgment the month that it's not paid. And therefore, that's the parent's right, not the child's right. The child's right is to future child support. And we are not asking to waive future child support here. We are asking the court to set a deviated child support with a stepped up basis because of my client's other two children after taking a look at all of the financial circumstances. And again, that's a modification that my client has had to file because of the difficulties on these arrears. She also it discusses and cites that Pippin's case, which again I would argue is unresponsive to the facts of this case. The Pippin case involved an order modifying child support when the parties had entered into an agreement under the auspices of terminating Mr. Pippin's parental rights, and therefore the obligation to pay future child support would terminate if, in fact, his parental rights had been effectively terminated. The court concluded that his parental rights had not been terminated, and therefore he had an ongoing obligation to pay child support. And the Pippin's case goes on to discuss latches and ruled that latches are equitable, and this is a quote from where it's citing the Hartman v. Smith case. Latches or equitable estoppel may be utilized as a defense to an action by the custodial parent only if it can be done without harm to the child. While latches has been allowed as a defense to an action for past due support, it has not been applied to bar prospective support. And again, we're not asking for that. To do so would contravene public policy. Here, Ms. Pippins sought a modification with regard to future support, not past support. The defense is not applicable to such an action. Additionally, application of latches to such an action would most certainly harm the children. That, again, meaning future support. So I think the argument of Pippin's in counsel's memorandum is misplaced. One, because we're not asking for future waiver of child support. We're asking the court to acknowledge the parties' agreement that they have entered into, that they've acted and relied upon, enter a finding that child support is current through, and we would submit through December, at least December 7 when we filed, and that there should be no child support arrears owed to Ms. Pionio, again, which she seems to acknowledge, and that technically there should be an award to my client for the collection of child support from July to present. As of February 2, that amount was $6,875.74. We also provided under sealed financial source documents verification that there's sufficient assets available for those to be paid within 30 days. So looking overall, it's our request that the court establish child support to commence April 1. We're here March 6. We'd be entering a child support order. Subsequent to this, obviously, we're asking that you set it at $600 per month, effective April 1, allow for a stepped up basis at $300 per month for 6 months. Continue with the allocation of the tax exemption for Ms. Pionio to claim both girls for 2025, and then allow for Mr. Rice to claim both girls commencing with 2026 thereafter. We're asking the court to deny their request to add the additional expenses, again, without allowing for joint decision-making and the like, so that that's not abused moving forward. Quite frankly, I don't think college applications is right because that's a post-secondary issue and post-secondary is reserved. Again, quite frankly, I don't think that driver's ed and insurance is properly before the court. There's no evidence relative to those issues. It's not a right, it's a privilege to be able to drive. We don't know, we're talking about 11 and 14-year-olds at this juncture, so that's not ripened before the court. There's no proof of any additional expenses for attending public school, and the parties have agreed as it related to extracurriculars in the past. Overall, we are asking the court to award $3,000 in fees as it relates to the adjustment motion, and you can see all of the filings that we filed in December, the difficulties with discovery. Overall, my clients outlined, or I've outlined technically for you in attachment D, or tab D, as in Delta, my attorney fee certificate. Overall, Mr. Rice's fees are anticipated to run just under $24,000 for discovery and running calculations, and all to have at the 11th, 12th hour for Ms. Pionio to say, well, nope, I'm not asking for child support arrears. So we're asking overall for the court to award $12,000 in fees.
Okay. Thank you.
Thanks.
Mr. Levitt, I'll turn it back to you.
Thank you. I do have some rebuttal argument as to the case law. I agree that those cases were applicable to agreements to waive future child support, and that's what's non-waivable. In this case, the parties had an agreement in 2022. The agreement was for then future child support. It is that agreement that respondent is attempting to enforce here, and that any agreement as to future child support is non-enforceable against public policy. That's what the case law says. Now we are in 2026. That agreement in 2022 obviously happened years ago. So at this point now, the court can waive child support arrears. The court can say that there are no arrears. The court can set what those arrears are. However, at the time they made that agreement, it was 2022. The child support payments that would have accrued after that would have been future payments. Therefore, that agreement was non-enforceable. It was against public policy, as the case law has described. I want to clarify a couple things. First of all, the proposed child support orders that were provided by the state and that were provided by petitioner say that this order does not address child support arrears. That should be appropriately addressed through the Division of Child Support. That is what petitioner was stating in her declaration. I'm not asking the court to make any orders as to child support arrears. That's appropriately dealt through the Division of Child Support. If we go to Exhibit E, the email that was brought up by counsel, I will go through and read what my client stated on May 14th, 2025. The past due amount is incorrect. Jesse paid me $600 a month until August 2022. So the difference should be from September 2022 until current, not from December 2020 when it was changed to $600 a month. Then there's a period. I'm not sure if I'm going to waive that debt or not yet. She's talking about the actual debt that should be calculated by the Division of Child Support from August of 2020 or September of 2022 through the time that she sent this email. She's not saying that she wasn't sure if she was going to waive the debt for the money that she actually received. This is the first time that I'm hearing that argument, and that's fine. I just didn't anticipate it. And then the state goes back and forth saying, this is how I came up with this number. On page 14 of the February 23rd reply declaration, petitioner says he hasn't paid me in 33 months. Times $600 a month would be $19,800 past due. So I'm confused where the $34,000 past due is coming from. Throughout all of this, respondent has not communicated with the Division of Child Support. Respondent did not apparently make any effort to notify the Division of Child Support that there was this agreement, or if he did, no documentation was provided to the court. Let's see. Respondent states that there's no evidence to substantiate requests as to extracurricular activities and driving associated expenses, college application expenses. I find this argument to be a little bit preposterous. I mean, on the one hand, he's saying, yes, we have reached agreements in the past. I have reimbursed her for 50% of these child support expenses, but if it's ordered, then she's going to abuse that. I don't know how she could abuse it when our proposed order says that it would only be for historical or agreed upon extracurricular activities. The fact that there's no evidence of driving associated expenses is difficult to comprehend. The children are not yet driving, but they are of an age where they will soon be driving. And the idea that the issue of college expenses is not ripe, frankly, I disagree. I think that the court is reserving for post-secondary support, and the court should reserve for post-secondary, but we don't want to require these parents to come back to court to modify the child support order. You know, when the oldest is in her senior year of high school, just so that she can get that amount of contribution from respondent. Maybe he would agree at that time. Maybe he would agree. We don't know. But what we do have evidence of is that when he's not paying support, when he's not paying any child support to petitioner, then he is willing to agree to these other expenses. A couple other points that I wanted to address as to the deductions from the rental income. All of the deductions filed, again, not under seal, but the submission for financial documents that was filed on February 27th. Every single deduction there is for a regular business expense that was actually paid by petitioner or her husband and was actually accrued for they were the normal business expenses for the business for tax years 2022 through 2024. There are page references that refer to the actual tax returns. They correspond to the amounts that were reported to the IRS. Respondent's position appears to be that because we didn't claim these particular normal business expenses, rather instead proposing a 10% deduction, she shouldn't be entitled to those deductions. I don't think that's supported by the case law or by procedural rules. We did have a deduction included. It was different than what the parties actually incurred because we didn't want to go into this much detail. Let's see what else. Again, there's this attempt to rely on an agreement. That agreement was unenforceable at the time that it was made. The alleged damage to respondent that he can't go back and retroactively modify child support is interesting. But again, that is not the type of damage that was contemplated by these equitable defenses. I did, by the way, go back and look at my notes for what the third defense was, and that's called an equitable offset. It's when the defending party paid actual expenses for the children and reduces his or her child support arrears by the amount that they paid. And that is not being claimed here. When we go through the other two equitable defenses, we have latches. For latches, there has to be knowledge of the facts constituting a cause of action, unreasonable delay, and then damage to the defendant resulting from the delay. again, I don't think we have that. The type of damages that the respondent is claiming here really are not related to this delay in support enforcement or the request for support. He's claiming there was an agreement in 2022. She delayed from 2022 to 2025, and then that's when support began being collected. I have found no case where the non-custodial parent was entitled to reimbursement for validly collected child support arrears based on an equitable defense. If any such case exists, I'm not seeing it populated in Westlaw. I understand that he wants the court to honor that unenforceable agreement. He wants to say that, I'm entitled to repayment of all of these funds that DCS has collected from me since 2025, but that's simply not available. And then as to whether that delay was unreasonable, petitioner provided her explanation. She didn't provide any evidence because, frankly, it's not her burden to prove anything related to this, related to that agreement. That burden is squarely on respondent. And the evidence that he provided is a text message where the parties say, petitioner says, I want to claim both kids because I'm waiving child support. Respondent disagrees. There is no further discussion. It is respondent's burden to prove that he relied on that agreement and that he was damaged for relying on that agreement, or that he was damaged from the delay in enforcement. And as Capetillo itself states, he can't prove damage simply by showing he has to do now what he was legally obligated to do for years. As to the equitable estoppel claim, it would mitigate the harshness of child support arrears, but he has to prove all three elements again to that higher standard, more than just a preponderance of the evidence. There's an admission, statement, or act inconsistent with a claim afterward asserted. I believe he's referring to the text where she says, since I'm stopping child support. Again, at the time, it was as to future support. That agreement, unenforceable against public policy at the time that it was made. And there was no benefit to petitioner until years later when she eventually did, and the parties did actually agree to have her claim on the taxes. That evidence was not provided by respondent, and that is his burden. I have some other.
Let me kind of stick there just for a second. So
Yes.
what I'm trying to kind of wrap my head around as I walk through this is she has this idea in September of 2022. Now I walk past her income, but it's right about that time that we see her income from the business with the new husband kind of go up. It was at 3,000 for many, many years. And then we see it kind of bump up. And then right in that heart of 2022, 2023, I think there's even one quarter where it's at 20,000. And that's about the time when they take a distribution of 300 to 6,000. I mean, the picture that's being painted for me is there was a benefit to her because in the height of 2023, when real estate market is still hot and that probably this home inspection company is doing really well, they pull out this large distribution, and the way to get more bang for their buck is by having more deductions. So she has an idea that, hey, I can get both kids. I want less income. I want more deductions. And she's the one who proposes it. I mean, that's kind of the struggle I'm having here. Is it appears like she proposes this idea because their income's going through the roof in the height of a real estate market. And now we start entering 2025. We can all agree things have cooled down significantly. And now all of a sudden, this isn't her agreement. This isn't her idea, and she wants it enforced. And I guess I'm struggling with why why in 2025, after him not paying since 2022? Why now? Why in 2025? I mean, I see it. I see there's been a drop in income. She's now getting a little bit less from the home inspection company. I don't have records of what the business income was for 2025, but I'm guessing it was less than 2023 and 2024. I mean, it was her idea. She sent a message saying, I'm dropping support and I want the deductions. And then she takes the deductions. And then even sitting here preparing for this case, she writes in her reply, hey, judge, if you take our deductions away, we need a little time because that's going to be a burden to my husband and I with less deductions or exemptions, excuse me. So I guess help me understand how she has not asked for two different things depending on her financial state.
I mean, Your Honor, she did ask for it in September of 2024 or September of 2022, but it was not agreed. She waived support unenforceably, but she did. She waived support in 2022. It was not agreed. And thereafter, sometime later, with the benefit of hindsight,
Yeah,
there was this agreement. And when I'm looking at case law,
why did she take, and I understand, I 100% agree with you, Mr. Levitt. I am troubled that your client would propose an agreement that is void as against public policy for future child support. I think that is very clear. But at what point does she say, or why does she then, I guess let me back up. Why does she then go ahead and take the tax exemptions for both kids?
ultimately, Your Honor, I don't have an answer for you. I think the parties could give you an answer, but frankly, they're both prohibited from doing so by the court rules. This is a trial based on the pleadings only, and the burden was on respondent. And I'm not trying to hide the ball here, but
Yeah.
when I look at case law, burdens on respondent to show we had an agreement and she got the benefit of the bargain already. The evidence that he provided shows there was an agreement as to child support, but there was no benefit to petitioner until a year, 2 years, at some point later.
Well, she and her husband were obviously planning to pull a large amount of money out from the company because they took this $300,000 distribution. And they knew that the way to plan for that was by having more write-offs. I mean, I think that's logical. And so I understand the black letter law, just the smell test here. I mean, I don't know what to think of this. I have an individual who proposes to her husband, hey, stop paying me. Let me and my husband, where we have $250,000 in income now, let us take the kids as exemptions. And he says, nah, I don't want to. There's some kind of phone call happening where she must convince him to. This is her idea. This is not him pushing her into it. He says, I don't want to do it. Something happens. I don't have that information. He stops paying. I think if she had to file her taxes the next day, she would have taken the exemptions, but that's not how tax filing works. So she waits until they file. She actually, as I understand it, for 2 tax years now, has taken both girls or both children as exemptions. And that is in contradiction to the prior court order too. So she's doing something she knows she's not supposed to be doing based on this agreement that she's talked to him about. So, I mean, that's what I mean is, how can I say she has, it's very, I think that you understand the concern. I understand the law. I understand the black letter law. I understand public policy against waiving a child's right to child support. I understand that we have orders in place. I understand the burden of proofs here. When you look at why each person did what they did, it just seems clear to me that at the time in 2022 and 2023 and some of 2024, it did financially benefit her to take these exemptions and have less income. And now, maybe less so, because incomes are going down as based on what I'm seeing from employment security. I mean, that's the heartburn I have here is now, 3 years later, I'm being asked to find that this wasn't an agreement or can't be enforced. But she asked for it, and it maybe didn't benefit her that day that he stopped paying, but she was planning for it to benefit her financially. Because we see just whatever, how many ever months later, they pull out $300,000.
No, Your Honor, I fully understand. I think this is an issue that the court has to grapple with. And that's why I'm focusing on this is what the letter of the law says. This
Understood.
is what the equitable principles are. This
Yeah.
is the evidence that we have. And so I'm providing
Yeah.
my understanding of what all of that means.
Yeah, I think this just,
I
I know. Let me ask you this question.
okay.
Because I do think it hasn't been entirely clear. Is your client asking this court to award her the $19,000 in change? Is this court asking her to find that arrearage is owed to her?
No. Petitioner is asking the court to make no order as to child support arrears, as that should appropriately be done through the Division of Child Support. She has acknowledged or attempted to acknowledge every payment that she has received through the Division of Child Support, as she has provided evidence of. And so if there is a finding that he doesn't owe the child support arrears, that does need to be included in the order.
Mm-hmm.
But if the court finds that those equitable defenses do not apply because they're not supported by case law and the rules of equity, then the order can simply say, this order doesn't address past due support.
But then we all know sitting here that support enforcement's getting it wrong because they think it's over 30,000. So then do they have to file a new action? If I don't address it, if I don't say yay or nay to the 19,000, then doesn't some party have to come back into court on a new action to tell support enforcement they're doing it wrong?
That's correct.
Nobody wants that. And the evidence that I've attempted to provide is showing that on her part, petitioner has gone through the steps that she is responsibly and ethically doing to show that, look, he paid through 2022. He does not owe that much. Mm-hmm. And as far as I understand, petitioner respondent has been silent with the Division of Child Support, only coming to court after all of this came and there was a new child support order sought. Okay.
And then last question, and I'll let you get back to your thing. And then Ms. McLean, you will also have a chance, I promise. So she's not asking me from her side of the case. She's not asking me for a judgment in the amount of this $19,000. She says that can be left in the hands of support enforcement. But she is asking me to find that the agreement she asked for never came to fruition, correct? That there was never an agreement for him to stop paying. Is that right?
No, there was an agreement for him to stop paying. As far as what she is requesting for the court to order, she's asking the court to order that the requested equitable defenses do not apply.
Okay. Understood. Okay. And then I know Ms. McLean, hopefully I won't. Did you want to speak, Mr. Love? I know you're still in the middle of rebuttal, and I understand. Ms. McLean, did you want to speak briefly on the points we were just talking about?
So the only things that I would comment, there was although this this might be part of response to the rebuttal. The comment by counsel that my client has only paid 50% of agreed extracurricular activities after September of 2022 and he's not paid child support is not accurate. He's always paid 50% of agreed extracurricular activities. And again, I think those are borne out in the child support, in the bank statements for that time frame prior. And then as it relates to the issue of the arrears, we have included that in our petition. That is properly before the court. It does need to be addressed because the Office of Support Enforcement in our calculation is not getting it right. And if you don't address it, they're still collecting from him right now $1,100 a month against a $32,000 arrearage.
Okay. All right, Mr. Levitt, back to you. Hopefully I didn't throw off your flow too much there.
You've thrown off the Emperor's Groove.
I am sure.
No, I went through and highlighted the parts that I hadn't touched on, so I wouldn't lose track. Council brought up the $4,000 of gross income from petitioner's husband that's included in her financial declaration. I have that financial declaration pulled up if I can find it. Yes, this was filed on December 1st. In section 5, petitioner states, my husband's income above only includes his paycheck income. In addition to his paycheck income, he is the owner of Pacific Pole Inspection, LLC, receiving owner's draws. He also receives the other half of the income from our rental properties. See sealed financial source documents filed separately, and those sealed financial source documents that were filed at the time did include their joint tax returns from 2022, 23, and 24. They did not include the business tax returns. But they included the schedules that showed what the business income was, as is required for personal tax returns. Excuse me. There was no, I don't know. It's not that she was not being forthcoming. It's that it was clearly explained that is his payment, his pay stub draw. But there's also owner's draws. That's more complicated. It's filed under seal. Okay, I'm going to cross that one out. The argument that the state's withdrawal therefore kind of lapsed the state's motion, my response to that is that the state was not the party in interest as to the motion to adjust child support. So the parties in interest are the petitioner, the children in particular, and the respondent. They have not withdrawn anything. And even in petitioner's motion to adjust, she states, I'm filing this out of an abundance of caution. The state's motion was filed in July and to my knowledge is still pending. It was contemplated at the time that discovery needed to happen. And that's why the state eventually decided to withdraw. That was agreed. As to discovery happening and there being issues, discovery was issued, I believe, mid to end of August, and then nothing was heard from council until discovery responses were sent. There was no request for a 26I, there was no follow-up email. There was nothing. We sent discovery responses. Then on December 5th, we received a letter of deficiencies. December 22nd, less than 3 weeks later, we provided all of the requested documents except for a photocopy of her driver's license and social security card. To say that, the court should somehow hold that against petitioner or find that petitioner was not acting expeditiously, there's nothing from respondent showing that he was acting expeditiously to move the case forward. It was essentially we issue discovery requests and then we sit on it. It takes a lot longer to fill discovery requests than it does to issue them. Let's see. When we look at the state's document that was filed under seal, showing the hours that each party paid, I believe counsel was actually looking at respondent's Social Security income. It was respondent himself who worked 120 hours in Q3 of 2024, earning $13,597. Petitioner was working, but again, hers are later on, and her hours are reported on the 5th page of the sealed source documents that were filed on July 11th. I believe the hours portion is essentially a fiction, and for petitioner, she's salary, she gets $5,000 a month. I don't know where the hours come from. I don't believe that is coming from the pay statements or an hourly rate or anything, but I could be mistaken. Also, this is the first time hearing of any request that she be deemed to be underemployed. And again, that's fine. I just don't know that the evidence is necessarily there, but that is within your Honor's discretion to make that ruling. I believe I have addressed all of the issues that I marked to address. Thank you.
Okay, thank you.
The only thing that I would clarify is, if I understood Mr. Levitt's suggestion correctly, under tab 5, page 18, that is Ms. Pionio's employment security data, not my client's.
There's both.
Yes.
There's
Page
both.
5 is wife's. Page 2.
Yeah.
Maybe I thought you were referring to page 2.
Oh yeah, no. And that's just because that was a partial quarter.
Yeah.
So no, I was referring to page 18, which is hers, which clearly shows a history for, it looks like from second quarter 2020 through first quarter 2025 of roughly 120 hours a quarter.
Yeah, I'm sorry for the confusion. I agree.
Okay.
That is wife's.
All right.
I'm
Thank
trying to
you.
get both of you. Like Bates stamps 15 through 17 are his, 18 are hers.
Right.
Yeah.
Okay.
Ms. McLean, anything further?
I don't have anything further. I guess I would just ask, when do you want us to check back with you on a potential ruling, and do we want to potentially set a prospective presentation date?
Let's do this, noting that I certainly, as I thought about it more, I think that in order to avoid, if you're out in April and let's say it's an order that you want to file for reconsideration on, what day are you out of the office starting?
I'm out the 1st through the 30th.
Oh, so okay,
The whole month.
Okay.
Yeah.
So I'd like to get a decision to you. I'd like to get orders signed by the March 20th, so that both of you are in office and have time to file for reconsideration if you wish.
Okay.
And so I'd like to get my written bench ruling to you by next Friday. And then we could put it on for presentation of orders based on that bench ruling and or any clarifications. If you both are available, Friday morning, March 20th, at my presentation time, which is 8:45 a.m. via Zoom only.
That's fine. That works for me.
Mr. Levitt, does that work okay for you? If not, I have some alternatives I can propose.
Yes, I didn't realize I was muted. That does work for me.
Okay. Okay. So I'm going to calendar this for me for next Friday to have my bench ruling emailed to you, and then I'll have the parties back in 2 weeks from today at 8:45 for presentation.
Okay, and so is it safe to assume that we're working off of my modification and I'm going to be responsible for preparing orders?
That is an excellent question.
I think both of us have prepared orders in this case.
Yeah.
I'm happy to go with
Why don't you,
counsel or myself, either way.
let me ask both of you this.
Sure.
Do either or both of you have your proposed orders in a Word format?
Yes.
Yep.
Could you have your, and obviously copying each other, but email me Word documents of your proposed orders?
Sure.
I might be able to incorporate my bench ruling in those and save everyone a little bit of time, depending on what I do.
Does that include, do you want the worksheets in Word?
I dislike the worksheets tremendously, but sure, go ahead and send those.
Well, but it means that you'd have to manually manipulate it rather than doing like maybe Excel, or else you could shoot numbers out to us and we could get you updated calculations.
Yeah, why don't you do this? I'm not going to create new worksheets.
Okay.
So that might be the only thing that you all have to do, but send me your proposed child support order, final orders, modifying, etc.
Okay.
And I'll play around with those. But yeah, they actually canceled our subscription to the child support worksheets. We used to be able to do them from the bench with the calculations auto updated, and we don't have that anymore. So
I have an Excel template that includes the new support worksheets and the new schedule. I will email that to Your Honor as a blank form, so you have it. It is, I guess, somewhat proprietary because I made it here at McKinley Irvin, and they haven't told me that I can't share it, but
Well, yeah, you get to include me on that email.
sure.
If you want to, I will delete it after I'm done with this case.
No, I'm saying if they removed your subscription, I want the bench to have it.
Oh, yeah. I know. I think there were enough judges that feel like I do that we don't want to mess with the worksheets, that we weren't doing it anyway. So it was kind of
Okay.
$50 a month of wasted money. But okay, send me what you have.
Okay.
If for some reason you all get orders from me next Friday and we don't have to do presentation and you all take it from there, that's fine too.